Hello friends, in the series on the income tax cases, today we will discuss a case in which there were three issues before the Jodhpur ITAT. The first issue was that if the assessment of the assessee is completed under section 153C on the basis of combined satisfaction note for various years, so whether in that case the assessment based on a combined satisfaction note for different years is a valid assessment under section 153C. And the second issue was that if in a partnership firm the partners introduces the capital, whether in that case the addition under section 68 can be done in the hands of the partnership firm where the partners have introduced the capital, or the addition should be done in the hands of the partners. And the third issue was that if the assessee debits some profit and debits in the profit and loss account some expenses in the form of conversion and development expenses, so whether in that case the addition for those expenses can be done, especially in a case where those expenses also becomes the part of the closing stock of the assessee. These all three issues have been decided by Jodhpur ITAT in the case of Anjana Construction versus Assistant Commissioner of Income Tax. This case is reported in 128 ITR Tribunal at page number 148, and the date of the judgment is 29th September 2025. In the present case, three assessment years are involved: assessment year 14-15, 15-16 and 17-18. And the assessment for the assessment year 14-15 and 15-16 was completed under section 153C. When the matter was before the tribunal, the assessee took a ground that the assessment for the assessment year 14-15 and 15-16 has been completed on the basis of reopening under section 153C, which is based on a satisfaction note which is not separate for the separate year and which is a combined satisfaction note. When the tribunal heard this ground of the assessee, the tribunal was of the view that in light of the decision of the Supreme Court that the separate satisfaction note should be prepared for separate year, because the concept of recording the satisfaction is that the assessing officer has to demonstrate in the satisfaction note that how the material with the assessing officer has a bearing on the escapement of the income of the assessee. So when these satisfaction notes are prepared in a combined manner, so that do not fulfill the requirement of section 153C, and any assessment which is based on the satisfaction note which is a combined satisfaction note is not as per the mandate of section 153C, and the tribunal quashed the assessment proceedings for the assessment year 14-15 and 15-16 on the basis of a combined satisfaction note. As far as the second issue was concerned, the tribunal said that in the present case the CIT appeal has well appreciated that the assessee has duly disclosed the source of investments made by the partners in the partnership firm, and even the assessee, that is the partnership firm, has also proved the source of the capital. So in that case the order of the CIT appeal should not be interfered with. Moreover, the tribunal said that if any amount is introduced by the partners in the fund, in that case the addition is justified only in the hands of the partners and not in the hands of the partnership firm. The third issue was that if the assessee debits some conversion and development expenses in the profit and loss account, at the same time those expenses become part of the closing stock, even if the nomenclature of that closing stock is put as a capital work in progress, that does not matter because the nature of the expense is important, and the important part is that those expenses forms part of the closing stock. So in that case, if the assessee debits some expenses in the profit and loss account, and at the same time that amount also comes into the closing stock, so in that case that has the tax neutral effect and the addition should not be made on that point. So in the present case the three matters go in favor of the assessee, and the additions were deleted by the tribunal. At the end of this video, once again I am repeating the name of the case. The name of the case is Anjana Construction versus Assistant Commissioner of Income Tax, and this case is reported in 128 ITR Tribunal at page number 148, and the date of the judgment is 29 September 2025. Thank you, friends.